Welcome. I'm Karen Engel, and I teach here at the law school and co-direct with Neville Hode over there, the Rappaport Center for Human Rights and Justice. Welcome to the third event in our semester-long colloquium on reproductive justice, criminal law, and the carceral state. Especially, but not only, because it's Indigenous Peoples Day, I'd like to recognize that we're meeting on the indigenous lands of Turtle Island. Moreover, I'd like to acknowledge the Alabama Coushatta, Caddo, Carrizo, Comecrudo, Coahuiltecan, Comanche, Kickapoo, Lipan Apache, Tonkawa, and Isleta del Sur Pueblo, and all the American Indian and indigenous peoples and communities who have been or have become a part of these lands and territories that we now call Texas. We're benefiting in some ways from not recognizing Indigenous Peoples Day here because we're meeting, and that it is recognized in Massachusetts and at Boston University where Aziza is. But it is a school holiday in Texas, so I know some people aren't able to be here who wanted to be here. And I have many greetings to pass on. So this colloquium, as most of you know, is part of the Rappaport Center's relatively new Sissy Farenthold Reproductive Justice Defense Project. And Blake Rocap and Cristina Ramirez run that program. And it's also part of a seminar that I teach, and the students are, I thought you were gonna mess me up and move around, but it's great. They're still at these two tables, so you can ask them all the hard questions, and they can ask them all to you, Aziza, who I'm now going to introduce. So I will say the students have read some of the work of Aziza Ahmed, much of which she will present today in her talk entitled Floating Lungs, The Law and Science of Pregnancy-Related Prosecutions. And they've also read some of the work of Jennifer Lauren, who will respond to Aziza. And we had class last Monday and had a terrific discussion about the work by both of you, so it's great to see you all together and to hear from you today. I will have the students have the opportunity to ask the first few questions, but we'll have a lot of time, so everyone will have a chance to jump in. So with that, it's my enormous pleasure and honor to introduce Aziza Ahmed to you. Aziza is professor of law and Neil Pike Scholar at Boston University School of Law. And she's also co-director of a relatively new BU law program on reproductive justice. She's also on the advisory board of our reproductive justice project and has really been instrumental in the formation of it from its beginning. And I was just thinking of all the service that Aziza has done for us, from answering phone calls and texts about anything that has come to my mind in this area for the last over a year, as well as the students reminded us that you've spoken, this is the third time to speak in 2 years, not bad, at the law school, except this is the first one in person. So she did speak to Ifwin Howe last year and also was a respondent on a talk that the Rappaport Center, that the project sponsored. So it's really wonderful to have you here in person, Aziza. That means she's been introduced to some of you before, but I'll just say she's a leading scholar in law and public health with work at the intersection of law, politics, and science in a number of fields, very impressive wide-ranging fields, including criminal, constitutional, health, and family law. She's the author of many, many journal articles and a forthcoming book entitled Feminism's Medicine, Law, Science, and Social Movements in the AIDS Response. So you will come back and present that to us, Aziza. Much of Aziza's work over the past 10 years has involved reproductive justice and the relationship between law, science, and medicine in that context. So I actually, even though she's published an awful lot, even since Dobbs, I asked her to present this paper today because of the continued use of the floating lungs test, and ProPublica just published an article on it on Saturday and featured some of Aziza's work, and she was quoted in it. And not just then because of the ongoing importance of the use of that test, but because of its larger lessons for thinking about evidence, science, and medicine in the criminalization of pregnancy. So after Aziza speaks, we'll have the opportunity to hear from Jennifer Lauren, my colleague here at the law school, and who many of you know from class and elsewhere. Jennifer Lauren is the Wright C. Morrow Professor of Law, and she's the obvious person to respond to Aziza's work, both because of her own expertise on the uses of science in criminal law, and because of the major role that she has played in the Reproductive Justice Defense Project and continues to play. So really great to bring both of you together here, and it's my pleasure to introduce both of them to you, beginning with Aziza.
Thank you so much, all of you, for coming. I know the students have to be here, but thanks for reading my work and being a part of this discussion, and to all of you for making the time. And thank you especially Karen, who has been both a mentor and friend, and whose work I use heavily in my own. Blake, Caroline, for all the logistical support, all the Rappaport Center staff, and Jennifer especially, thank you for the comments. I know this is extra work, and I really appreciate being in conversation with you today. So my presentation picks up on a really specific set of issues at the intersection of reproductive justice, health regulation, criminal law, and race, and within the context of bigger questions I've been thinking about on science in courts and the use of science in abortion jurisprudence and the debates that are engendered when experts sort of battle each other in the space of the courts, but also in the legislature, and also as mobilized by social justice activists. In this paper, I was interested in thinking about the question at the broadest level of how the law legitimates certain types of expertise and evidence, and vice versa. So how expertise and evidence gets used to legitimate particular types of law and lawmaking, in this case, the prosecution of this woman, Purvi Patel. And I thought I would talk in a more specific sense, as you guys know, about the floating lungs test. And it's been used in the context of stillbirth prosecutions. And I'm going to give you a little bit of context about the case and the paper and why I'm interested in this, but also the history of the test and the cases that, this case that brought it to national attention, the way we ought to understand these types of prosecutions after Dobbs, and then how all of this fits into a bigger story, some bigger ideas that we can take away from these types of prosecutions. And I'm going to keep an eye on time. I don't actually know. I didn't time myself, but I'll make sure not to go too long. So like I said, this paper builds off of an earlier paper. The paper that I'm talking about is a paper about the floating lungs test, and I'll get back to explaining the details of it for those of you who haven't read it. But I've been really interested for a long time in questions about how science has become politicized in the context of the abortion debates. The deployment of a sort of conservative science, or a science that validates liberal and progressive claims about abortion. And this has come up over and over again in the abortion context. I won't talk about this as much today, but for example, we saw it in Carhart when Justice Kennedy says, that women, of course it's natural that women would come to regret their abortion. We see it when we talk about the actual abortion procedures in Carhart. Are the procedures valid procedures in a later abortion and a later in pregnancy abortion? What procedures have an evidence base behind it? In that case, it's the right that's saying, well, no, you progressives don't have the evidence base to prove, for example, that this is the right procedure. And we see it in whole women's health when, for example, in Texas, you get competing experts in the legislature, experts testifying before legislature, and physicians who are basically making competing claims about what is safe when it comes to abortion provision. And I'm also really interested in, and this paper really focuses in on the question of criminal law and reproductive justice, where there's a long line of cases where questionable evidence gets deployed in order to basically allow for pregnancy-related prosecutions. Dorothy Roberts has written a ton about the supposed crack baby epidemic. Deborah Turkheimer has written a lot about shaken baby syndrome, for example. And in these cases, shaky scientific propositions are put forward to aid in the prosecution of women in the context of pregnancy and childbirth. So when we think about the supposed crack baby epidemic, the idea was that women were giving birth to these children who were giving birth to children who were basically addicted to crack cocaine, and they should be prosecuted essentially for delivering drugs to their fetus. And that led to many prosecutions, especially in South Carolina. And it was all based on a small study with an N of 23 that was essentially debunked, and the entire crack baby epidemic was eventually debunked. Again, with shaken baby syndrome, which has been described as sort of been created by the courts in an attempt to try to figure out who should we hold responsible for the death of a child. And actually, just recently, it was in a New Jersey court, they basically say that shaken baby syndrome shouldn't be taken seriously anymore. So that's, there's some really interesting things happening here now. I was interested in a similar set of questions in the context of the floating lungs test, which is a test that's used to prosecute feticide and infanticide stillbirths in most instances. And the paper was inspired by the Purvi Patel case, which is one of the higher profile cases of self-induced prosecutions in the United States. This is all pre-Dobbs, so we can think about, well, if this is all happening pre-Dobbs, what's going to happen post-Dobbs? But the facts of the case are basically that Patel becomes pregnant during an affair she's having with a man at the restaurant. Sorry, I know the students read this already, but just for anyone who hasn't read the paper. She gets pregnant while she's having an affair with a man at a restaurant that she manages. She fails to menstruate for several months, and at the encouragement of a friend, she takes a pregnancy test that turns out to be positive. On July 11th, she ingests an abortifacient she orders online. She begins to miscarry, and she delivers a fetus, which she perceives to be dead. She places it into a plastic bag and takes it to a dumpster. Then she goes to the hospital. Now, she's bleeding profusely. The umbilical cord is protruding from her body. And when she gets there, two physicians, one named Dr. Byrne and one named Dr. McGuire, the latter a member of the American Association of Pro-Life Obstetrics and Gynecologists, examines Patel. And he says, I think this must have been a 30-week fetus/baby in his description, and calls the police. So Patel describes the incident, tells them she's only 10 to 12 weeks pregnant. And the physicians, of course, determine that she's much farther along. One could, even at this point, start to wonder about the sort of objective dating process that's going on here by this physician. The physicians call the police, they go to the dumpster, they find the fetus, and we get to various autopsies that date the fetus between 23 and 25 weeks, which I'll talk about later. But most controversially, one of the pathologists reports that the fetus has been born alive, taking at least one breath. Now, when a child takes one breath, that means that if the child was born alive, then the person who gave birth to that child now faces much bigger consequences, because now there was an actual dependent that you could neglect or a person that you could kill, and so on. So the primary test for determining if a fetus or a baby has taken a breath is called the hydrostatic lung test. It's also known as the floating lungs test, more colloquially. And the test, as I mentioned, is necessitated to sort of make a determination. Was this a stillbirth or was this homicide? And in essence, the forensics exams takes pieces of the lungs and places them in water. If the lungs float, scientists record the baby as having been born alive, and if the lungs sink, the baby is thought to have died in utero. And in turn, upon sinking, forensic scientists deem the birth to be a stillbirth or miscarriage, exculpating the accused, and the test persists despite lots of vocalized questions about the veracity of its veracities by experts. So, and I just want to say this has a lot of international dimensions too. There's a sociologist at Harvard, Jocelyn Vitrino, who works on these cases in Latin America. And this test is used pretty frequently in Latin America as well. And in fact, while Patel's case was going through the court, in El Salvador, a country that has very harsh abortion restrictions, there were also a series of high-profile miscarriage and stillbirth cases where women were being accused of infanticide that were also on appeal. And in those cases, they also used the floating lungs test. And I know that Jocelyn, for example, had gone to testify in some of those cases. So after contacting forensic pathologists and the sociologists involved in the El Salvadorian cases, I sort of realized this is something that someone needs to sort of give sustained attention to. And so this is when I began writing this paper. So a little bit about the history of the test. So, the history of infanticide has always shared some overlapping history with self-induced abortions, people who want to essentially end their pregnancy. A recent Western history on the history of criminal laws on infanticide and abortion tells the story that we might think about the criminalization of infanticide starting in 1624 with the act to prevent the destroying and murdering of bastard children, which was largely responsive to concerns about illegitimacy and the growing poor. Now, these laws were being passed at the same time as the Salem witch trials, of course, and unmarried sexual women were largely understood to be lewd women. They became the target of the prosecution, various types of prosecutions, but the prosecutions were often treated with some leniency. This is something that Michelle Oberman has pointed out in her work on infanticide. By the 18th century, however, Enlightenment thinking had come to impact infanticide trials as well. So the Enlightenment was, of course, this moment when reason takes over, law and science become very important in a lot of different avenues in life, and in courts and prosecutions as well. And here, the idea became that unless there's forensic science or some scientific fact, a woman shouldn't be held criminally liable for an infanticide because it was so difficult to prove whether or not there was an infanticide. And in 1803, a British law began to treat infanticide cases like all homicide cases, requiring a live birth, and so on. But still, there were difficulties in proving life. Now, two tests began to become appealing again in this period in the 1800s, and one of these tests was the floating lungs test. And so, of course, my paper focuses in on that question. So what is the specific history about the floating lungs test? Some people believe that the idea that oxygenated lungs floated first start all the way back with Galen, a physician and surgeon in the Roman Empire in 140 AD. You know, there's all these competing histories. There's no one good comprehensive history of the test. According to other histories, an actual forensics test didn't actually emerge until the 17th century, but of course you might remember that, you know, this was again the Salem witch trials period, and the floating water thing really seems to hit home in the advocacy around this test, because you just think like you're throwing something in water to see if someone's guilty or innocent. It just has so much resonance with that moment. By the mid-1800s, the procedure gets standardized. And so this is a quote: the lungs are, quote, taken out of the water, the large vessels tied, the heart separated, the organs weighted to ascertain the proportion they bear to the weight of the body, they're immersed, the lobes separated, and lastly cut into small pieces. And if the fragments float, they are firmly squeezed in the hand and placed in the water. Now, as soon as the test was established, it was started to become discredited. So writing in 1836, Michael Ryan, a leading practitioner and ethicist, described the flaws of the test, saying that it's no longer utilized in Europe during the numerous issues that arise. This is, as I said, in the early 1800s, you know, including the ability of children, or fetus, to take a breath in utero, or as they're going out of the birth canal. So actually, even if the child dies as soon as they exit the birth canal, they might have taken the breath before leaving the birth canal. And even Michael Ryan says in 1836, some of our best jurists cling to this with a degree of tenacity, which, to speak within its mildest terms, is exceedingly remarkable. So despite the warnings the test is used, and in the paper I talk about the cases, and these are in Westlaw actually, you know, in the 1800s, where the hydrostatic lung test appears as forensic science in numerous cases, in Texas actually, in which African American women are accused of killing their infants. And many, something that's an interesting dynamic here that I emailed a couple of people, historians, about to see if they could help me suss out why. Many of the women in those cases are actually found to be innocent, and I think that must just be because, in keeping with Michelle Oberman's sort of suspicion, infanticide cases were actually treated with some sympathy by courts, and this is maybe even despite the fact that they were African American, though there's a lot of racist stuff in the decisions themselves. So the doubts about the HLT, the floating lungs test, are never resolved. And in contemporary cases, we see all this remarkable similarity to the questions today that they're asking today with the questions that they were being asked in the 1800s. And so in 2000, but let me just say that despite all this debate, and despite the fact that forensic scientists are uncomfortable with the test, it continues to also be proclaimed as the only test, or the best test. So in the 2006 version of a medical legal investigation of death guideline, for example, the floating lungs test is described as the best test for assessing when there is that there is air in the lung. Okay, so how does this happen? What's going on in the Purvi Patel case? Well, as I mentioned, Patel is ingested an abortifacient. She thinks she's 10 to 12 weeks pregnant. Turns out she's somewhere more like 22 to 25 weeks pregnant. She's charged with feticide and neglect of a dependent, leading to death. The prosecution tried to prove that the fetus had been born alive. But something to note is how differently the floating lungs test and the pathologist reports looked when they were presented by the prosecution and defense. So during the trial, the state argued that Patel was a cold-blooded killer, a mother, quote, who put their baby in the garbage, quote, and then went for help only for herself. The defense painted her as a confused woman, unclear about the realities of her pregnancy and how to manage it, who gave born to a stillborn child, disposed of it, and went to the hospital in shock. One of the key pieces of evidence that's used in the defense is a set of text messages that Patel exchanged with her friend, Faye, who was a medical technician, and I just pulled those out for you here. Patel frequently texted Faye about her confusion around her pregnancy and that she thought she was 10 to 12 weeks pregnant. She's incredibly confused, as you can see from these text messages. So she tells her friend, I haven't had an appetite, maybe I'm pregnant. Her friend says, have you missed, meaning have you missed your period? I've been cramping like crazy. You need to take a test, hoping it goes away on its own. Didn't even take a minute to show I was pregnant. You have to go talk to a doctor. I'd rather not go to a doctor. And she says here, I realized that today I've missed 2, which would make her like 10 to 12 weeks pregnant. And her friend is saying, you really need to go to a doctor and sort out this pregnancy. The expert for the defense, Shakutias, attacks the floating lungs test. First, she argues, as scientists have been arguing, that the test is worthless itself, given the frequency in which stillborn children in hospitals will test positive for oxygen in their lungs, despite the fact that they are sort of known stillbirths because they're happening in the hospital setting. And second, she argues that even if it were reliable, the method that Pralo utilizes is problematic. Tia suggests several other tests that might be equally unreliable, but that could validate or invalidate the floating lungs test, perhaps, that involve conducting an X-ray on the body. Pralo did not conduct the X-ray prior to autopsy. Decomposition itself can introduce oxygen to the lung. And Patel opened the mouth of the fetus as she was putting the fetus in the bag, which means that oxygen could have entered the lungs that way as well. So the age of the fetus was also contested, and this is relevant because the age of the fetus at 24 weeks, the age of a viable fetus is 24 weeks, and the fetus was born, according to forensics experts, at 25 weeks. Yet the neonatal resuscitation program of the American Heart Association and American Academy of Pediatrics says that 23 to 25 weeks is a gray area for resuscitation. If Patel had given birth in a hospital, she might have had the option not to resuscitate the infant in any case if it had been born alive. But these are, of course, guidelines that have been subject to political pressures as well. As you know, many conservative states have tried to pass laws saying that it's mandatory to try to resuscitate all fetuses that could be on the brink of life, including those that are the product of abortion. So the trial court finds for the state that the baby was born alive and that Purvi Patel was guilty. But the appeals court, Purvi Patel was charged on 2 grounds: neglect of a death of a dependent and feticide. The appeals court found that feticide did not apply because it was not intended to allow for the prosecution of women who obtained illegal abortions or tried to self-abort. But because the court found that Patel seemed subjectively aware that the baby was born alive, she basically conceded the point, and I haven't really been able to get to the bottom of why she conceded that point. I've tried to track down people and ask, but she did concede essentially that the baby had been born alive, and that she knowingly endangered the baby by failing to provide medical care, but the state failed to prove beyond a reasonable doubt that the baby would not have died but for Patel's ability to provide medical care. The most important takeaway for the purposes of a discussion on the floating lungs test being that the court did continue to hold that a baby had been born alive, validating essentially the test. Okay, so I'll just maybe step back for a second and say a few things about the broader implications of this of the floating lungs test and the work that is going on in this space right now. So from a public health perspective, I think we can use the floating lungs test as a sort of a way to understand what the implications are for how lawmakers and others will approach the issue of self-induced abortion in the context of the post-Dobbs moment. Clinics are closing, medication abortion use will be on the rise, and if a person ingests medication abortion after the 10 to 12 week mark, which is a very likely outcome for a lot of people who are desperate to end their pregnancies, we can assume that these cases will also be on the rise, and that this test will be used if a medication abortion is ingested to essentially prove that there was something going on here that wasn't a stillbirth. The question on the table will be, whether or not women should be penalized, and will they be penalized, and how will they be penalized, essentially, for their late miscarriages. And I think, we were talking about this in a smaller conversation earlier, but I have here in my notes, this reveals one of the big downsides of the Mifepristone-oriented advocacy that suggests that women always know how pregnant they are. And, I've been talking about this a little bit more, but, one of the talking points now of the abortion in the reproductive justice space has become essentially that women know about women know how pregnant they are, that women know their bodies, that we can manage our own abortions. And while that's true in most of the cases, pre-Dobbs, it was very common for reproductive justice activists to say, a huge number of women don't know how pregnant they are, and that's why we shouldn't have early bans on abortion, because we actually don't know if we're pregnant at 10 weeks or 8 weeks or 6 weeks. So there's been this entirely large flip in discourse, and I think that the people who are going to lose as this discourse shifts or who are not being acknowledged are the people who are unable to sort of predict and date their own pregnancies. This test and the conversation around it, of course, also has a lot of implications for larger conversations about when life begins. And, it's kind of remarkable in a sense that we're still having, we're sort of in the process of working that out again, especially with the rise of fetal personhood laws. How the questions that they ask in the 1800s in some of the cases in Texas are the same questions that are invoked in the Purvi Patel case. And it's not just about conception or fertilization, but, when is a person actually alive so that you can hold somebody accountable, for example, in the case of murder? Is it when the child is fully out of the uterus, when they're fully out of the birth canal, when they're halfway out of the birth canal, when they've taken a breath, when they haven't taken a breath? There are all sorts of ways in which the courts invoke different markers of when life begins. And so, we have to think about what this is going to mean. And of course, if fetal personhood laws are passed, then this will mean much more, because of course, any potential ingestion of medication abortion could be a homicide if, what you're doing is essentially aborting a child. There's a lot to say here about race and the role of race and culture in prosecution's defense and culpability. And, this is, of course, a long question and an important question in the criminal law context at all, in general, and we're sort of course, in a big moment where we're rethinking, the role of the criminal justice system and the role of policing and accountability. And I really think that this story fits in that broader conversation. In some of the early cases, from the 1800s, you would get these very racial biology overtones as part of this conversation. In one of the cases I looked at, for example, they were trying to figure out if a baby who had been born to an African American woman had been alive so that they could potentially hold her culpable or not. And they brought in the woman who they thought had given birth to the child, and they say, but she doesn't look like she's just given birth to a child. She's basically like, it doesn't seem like she just gave birth to a child. And the judge says at one hand, well, the negress feels no pain. And, and they describe the child in these very racialized terms as a way to say, well, she could have given birth because, black women don't appear as they've given birth when they've given birth. So you get these kinds of racial discourses in those prosecutions. In the Patel case, although I don't really write about it in the paper, her defense attorneys do try to raise a defense based on what they say is a Hindu belief, which is that the baby isn't alive until their first cry. And it's really interesting that it has a sort of South Asian defense sort of wrapped in there, partly because, and I haven't quite made sense of this yet because I don't think there's enough cases to make sense out of, but like a lot of the cases that were happening in Indiana around self-induced abortion have been of Asian Americans. And there was so there was Bebe Shui who had ingested some rat poison, and then there's Purvi Patel. And then in New York, at the same time as I was writing this paper, there was another woman, Nosheen Rahman, who I've never established that they used the FLT in her case, but the news reporting all talks about the fact that she gave stillbirth, but she gave birth, but the child was alive, despite the fact that she claims it was a stillbirth. And of course, they come back to this test. Now, this is really Jennifer's area of expertise, but from a forensic science perspective, I think the case really raises additional questions that continue to haunt the forensic science community. Especially after the 2009 report that raised many questions as to the validity of certain types of forensic science, as well as the role of the courts in assessing science itself. Are judges capable of assessing particular types of science that are being put forward by the prosecution? Are public defenders able to have the resources they need to basically interrogate experts at the level they need to interrogate them in order to essentially convince a jury, for example, that the expert is actually wrong or incorrect? And there seems to be very little interest in the reproductive health context, except for now this kind of new attention that the floating lungs test is getting. around the question of, how should we be thinking about this forensic science? How much should we be interrogating this forensic science? There's a little bit of a reticence, it seems, from the part of judges to really sort of dive into the questions that they need to be diving into. And of course, if we think about this, and this is what's interesting to me too, in the context of all the abortion litigation that's going on, like there's these false claims about abortion based in some sort of medicine or science just flying all over the place, and seem to sort of pass muster over and over again in the context of litigation. And then finally, I think that the floating lungs test sort of begs a set of more theoretical questions. Significant questions about the role of science and the law and the broader political environment in which these cases are operating. So if we read the relationship between science and law, rather than seeing them as we typically do as sort of independent sources, like science is over here and law is over here, and law has its own reasoning and science has its own reasoning, and instead see them as co-productive, as constitutive of one another, we can really begin to understand how it is that the law has reinforced, has validated, has legitimated different types of forensic science, and vice versa. We have to ask ourselves, what purpose does this validation serve? And of course, in the criminal law literature, there's a lot about the need to blame and the need to arrive at finality in a court case. With evidence and expertise mobilized, shaped, and legitimated by the court for successful prosecutions around pregnancy and parenting, we get these large-scale this ability to do these large-scale prosecutions in the context of the crack baby epidemic and in the context of shaken baby syndrome, and now in the context of these stillbirth cases with the floating lungs test. And I wonder if we should interrogate how the law and our attempt in a desire for finality and blame has essentially propelled forward the conscription of science and evidence into a broader, you could say, neoliberal individual responsibility carceral agenda that prioritizes personal responsibility and accountability, and really works to undermine the broader support services that someone like Patel or another person in a situation where they're having a stillbirth, having no prenatal care, having had no sex education, having had no good public health care, would perhaps receive instead if we had turned our attention in that direction. And I think we have to pay attention to all of this, of course, as I mentioned earlier, in the post-Dobbs moment we're in, where these prosecutions are likely to become more common, and this is a very easy into the prosecution of pregnant women itself. So, as Karen mentioned, ProPublica just on Saturday did a big write-up about the floating lungs test, and CNN had a story about the floating lungs test in Latin America, and so I'm actually feeling kind of hopeful in this particular moment that maybe some of this will lead to a sort of dismissal of the case. And will it mean, if I say something controversial, maybe I said 25 things that are controversial, but like one more would be that will this mean that maybe we wouldn't be able to prove that some women had actually neglected an infant that they had just given birth to, for the sake of essentially not prosecuting many other women who are actually being prosecuted despite being innocent? I think we have to just accept that as a reality, because I think that's the way it should shift. I think that's the way the implications of this should go. I'll stop there. Thank you.
I'm going to take a moment to shift this over, because there's one and precisely only one thing I want to be able to show you all. There's that. Okay. No, that's yours. That's mine. Whoops. Okay, but okay, we'll get to that in a second. Okay, great. So thanks so much to Professor Engel for the invitation to comment today, and to Professor Ahmed for the presentation, for this terrific paper that I've actually long admired. I knew the paper long before this moment, but now I have the pleasure of being able to engage with the author in real time, so this is really great. So the paper is super rich. I could easily equal or surpass the length of Professor Ahmed's own remarks with my own, which would preclude discussion, and so I shouldn't do that. And so I'm going to keep my response probably a little bit more gestural than I might want, rather than digging in too deeply to each of the points that I want to make. But hopefully it'll serve to spark conversation with Professor Ahmed and also with all of you. So I have, I think, 4 points that I wanted to make, or questions or reflections that I wanted to offer up. And I wanted to start with the sort of broader context of forensic science, because that's sort of where my brain puts a piece like this. So I wanted to start by sharing a little bit about how I think about the floating lung test, which, by the way, is what I want to call it, because I worry that HLT lends it too much an air of sort of technical legitimacy, frankly. I want to call it what it is, floating lungs. So the way I think about the floating lung test in the broader context of concerns about the reliability of forensic science methodologies in criminal law, generally speaking. Because I think the broader context is actually important for understanding just how worrisome this evidence is, and forensic science evidence generally, in the newly forming landscape of pregnancy-related prosecution. So, floating lung tests are really just one example, one of many examples that we could point to of questionable, allegedly scientific methodologies that are being offered in a criminal case to prove something that the prosecution needs to prove in order to establish that a crime was committed by the defendant, right? And my essay points up some other notorious examples, bullet lead analysis, hair microscopy, bite mark evidence, and it's widely understood, really. This is no secret, right? It's widely understood, including by prosecutors and law enforcement, frankly, including within the forensic science community, that many methodologies have been employed and testified to despite an absence of neutral validation of those methodologies. It's widely understood that much forensic analysis is vulnerable to cognitive biases, particularly those that arise when analysts understand themselves to be sort of part of the law enforcement team, right? It's widely understood that courts have done a poor job in the expert gatekeeping role that is assigned to them by the rules of evidence, and particularly so in criminal law, where rather than a battle of experts, typically, right, forensic science expertise is sort of lopsided on the prosecution side, and defendants are often poorly situated to challenge it. And as my essay argues, which those of you who had a chance to read it know, it's also widely understood that forensic science has likely generated error in the criminal legal system, and that error is extremely difficult to unwind. Like, unique among errors in it being difficult to unwind. But I want to suggest that floating lung evidence exhibits some of these pathologies in spades, right? So forensic pathology and medical expertise more generally is within forensic science particularly sort of impressionistic, experiential, right? And given the demands of bioethics, largely impossible to invalidate or validate in a systematic way. You can't generate an error rate for this stuff, right? Because you can't just be grabbing lungs and floating them, right? We don't, that's not cool. Forensic pathology, particularly medical examiners, right, is a subset of forensic science that probably has made the least progress in recent years toward ensuring that individuals practicing in the field are well-trained, adequately resourced, and critically sufficiently independent from law enforcement and prosecutors to be providing objective opinions not shaded by preferred adjudication outcomes. And this is particularly so outside of large urban jurisdictions, right? Not for nothing, of course, these non-urban jurisdictions are also most likely, that are most likely to feature relatively poorly resourced and conflicted medical examiners, are precisely those jurisdictions, right, where pregnancy-related prosecutions have tended to and will continue to arise. So, which is all, as a first point, just a way of emphasizing the importance of Professor Ahmed's work in this space, right? All right, but there's another way in which I think that floating lung evidence is special, not singular maybe, but special in the broader context of forensic science evidence. And that pertains to the centrality of it in the cases where it is employed. And Professor Ahmed discusses this a bit in her paper and pointed it up a bit in the presentation. But I want to push the point even a little bit farther than I think she takes it in the paper, and maybe see what she thinks about the farther push of it. So as Professor Ahmed explains in discussing the Purvi Patel case, without a breath, right, the prosecution doesn't have a case, or at least not as serious of a case, right? Indiana probably could have prosecuted Purvi Patel for improper disposal of human remains or mutilation of a corpse, but that's not what they were going for, right? They wanted accountability for the death of a baby. Or more specifically, and now we'll go to the language of the indictment, right? All my criminal law students are like, no, she's going for the elements of the offense. Yes, she is. Buckle up. So tracking the language of the neglect statute, right, the prosecution was going to have to prove that Patel was more than 18 years old, that she had care of something that qualifies as a dependent, that she knowingly placed that dependent in a particular kind of situation, that situation being that they were endangering, right, the life or health of the dependent by failing to provide medical care, that all of that resulted in the death of the dependent, and that, by the way, the dependent was less than 14 years old, right? All of those are the elements of this offense of neglect that she was charged with. I'm not dealing with the feticide offense that the court ended up ultimately saying didn't apply to her conduct, right? So under Indiana law, right, only humans who are born alive can be dependents, right? So the floating lung evidence as part of a constellation of facts relied on to know the otherwise unknowable, right? Was the baby alive when Purvi Patel bagged and disposed of it, is central to establish the attendant circumstance of having the care of a dependent, right? But, and digging into the appellate decision in the Patel case actually really reveals this. What's fascinating and horrifying is the degree to which the floating lung evidence looms large in the prosecution's proof of virtually every other element of the offense, right? So what ends up being, according to the prosecution and according to the appellate court, the proof that Patel endangered the life of the dependent, meaning made it worse to any degree by failing to obtain care? The proof is that the baby breathed, right? And then was not cared for. That's the position the prosecution takes, and that's essentially what the appellate court says, right? What's the proof that Patel knew she was endangering the life of the dependent, right? That in the moment when this happened, it was flashing in her mind, endangering is going on right now, right? Well, the Indiana Supreme Court says, given that the baby breathed, the baby must have been doing other baby things, and that would have been apparent to Patel. And so Patel must have known that what was going on in that moment was the endangerment of a dependent, right? Because the breath, right? And, I mean, what's interesting is that ultimately, actually, this grounds for the conviction is reversed by the appellate court, right? Finding that the prosecution, in fact, actually failed to prove that the conduct resulted in the death of the dependent, failed to prove causation, essentially, right? But what was the state's argument? Essentially, that given that the baby was breathing, care would have sustained its life, right? Unfortunately for the prosecution, the science sort of ran out for it there, right? But that was the basis for the argument, right? In other words, in Patel, and likely in many cases where floating lung evidence is offered, the evidence doesn't merely go to one element of the offense. It's the entirety of the offense, right? It is, to use a phrase that's offered by Deborah Turkheimer, whom Professor Ahmed mentioned, it's a quintessential science-dependent prosecution. Without the science, there's just no crime, right? The floating lung evidence doesn't just link the defendant to a crime that's unquestionably occurred. It is the evidence that codes Patel's conduct and mental state as criminal at all, which all goes both to the sort of deeply delegitimating effects of the law abetting the use of such an epistemically rickety knowledge base, right? But also goes to its staying power, right? It's what isn't going to drive this existing at all. Okay. Third point, I want to pick up on and riff a little bit more on Professor Ahmed's fascinating insight in the paper, which sort of gestured to, but maybe didn't name in quite this way in the talk, about moral panic and floating lung testimony functioning as a scientifically objective tool that the criminal legal system wields to appear neutral while disciplining Purvi Patel's performance of motherhood, right? Like, we're not panicking, we've got science. You know, you're a real problem, not a made-up one, right? Is sort of the work that the science does there on that understanding, which I think is really interesting, and I'm persuaded. And I want to bring that observation into 2023, right? And the still evolving post-Dobbs landscape, because I think that the post-Dobbs surge of criminalization around reproduction has only increased, at least in some quarters, of felt anxiety, of panic, right? An anxiety around not knowing what pregnant people like Purvi Patel are doing alone in their bathrooms, right? I mean, on the one hand, outright criminalization of abortion actually stands to make floating lungs irrelevant, right? It's equally a crime whether the human being was born alive or not. But on the other hand, right, clinging to an epistemic tool for sniffing out what pregnant people are doing with their bodies when we cannot otherwise surveil them in the moment, nevertheless becomes more attractive and valuable as a concept in this moment, I think. And at the same time, it strikes me that, again, in this moment of sort of heightened legal and moral contest, right, over abortion and the question of control over pregnancy and reproduction, it becomes all the more important for the state to wrap itself in the mantle of neutrality, in the clarity of science and fact-finding. All we're doing is a simple test, says a doctor, right? And all we're doing is just proving each element beyond a reasonable doubt, says the prosecution. But in actuality, right, there's nothing simple or straightforward in the facts, nothing simple or straightforward in dating pregnancies, in defining stillbirth, and distinguishing miscarriage from self-managed abortion, right? Nor is the move from good mother to murderous mother a scientific, value-free move. It never was, but in a moment where there is perhaps a little more awareness of the political valence of these judgments, how helpful for the state to have a simple-to-administer scientific test to resolve these contests, right? So that's an observation or a question for Professor Ahmed about the sort of current state of how scientific evidence interacts with moral panic. All right, fourth and last, and this is great because it connects with where Professor Ahmed ended up. So we're going to pick that up. So I want to push Professor Ahmed a little bit on her way forward in the paper. She would have the legal system expunge floating lung testimony altogether. And she acknowledges one cost of this, the possibility of false negatives, right? Of losing the ability to criminally prosecute actual instances of post-birth homicide, however we define that, right? Well, I want to suggest that maybe that is not such a worry, but that maybe there's a different one that should trouble us. Because, both nature and systems of oppression abhor a vacuum, right? And so what I want to know when I imagine a world without floating lung tests being admissible in court is what has replaced them. Maybe that's floating lung tests that are performed and never used as evidence in court, but only in interrogation to facilitate confessions or partially inculpatory statements. Maybe, call back to Cynthia Conti-Cook, right? It's a greater incentive to engage in and collect digital surveillance and legal regimes that facilitate that more readily, that are responses to criminal legal actors asking for that because they've lost something that was useful to them, right? Maybe it's more sketchy science. I don't know. But in other words, maybe you win, but I suspect it might only happen when the system actors conclude they don't really need this anymore, that it's not worth the hassle. But if that's so, then there's necessarily something else we would need to worry about that will be greasing the evidentiary wheels of those prosecutions. And I wonder what you think that is, and I worry about it. All right, so thanks again for the opportunity to engage in this way, and I look forward to the discussion.